Thanks, Dan. And just a couple pieces of information, everybody, I'm going to throw in here, and thanks everyone for joining us. We've got two different things we're going to really focus on today to get you some information. First, we'll discuss things for employers to be looking at now as we kind of head towards the end of the year. We're less than 6 weeks out, and we wanted to just give you some information, get your mind in the right place to be thinking about some of these items. And second, we're going to talk about some thoughts that we have on how employment law related areas are going to change with a new federal administration that's incoming, and we want to just kind of provide some thoughts on what we think might be coming up ahead that could affect your business. And of course, just our standard disclaimer, this information that we're providing today is not legal advice. It's for educational purposes only. If you're already one of our clients and you have a question, reach out to us through our portal. If you'd like to become a client, we'll have some information at the end that you can look at. And now I'm going to throw to Andrew to start talking about some of our things today.
All right, thanks, Michael. Good morning, everyone. We're going to jump right into it with employee handbooks. Extremely top of mind for me because I'm currently updating our templates to make sure that we're all up to date for the law changes that have been passed and are going into place next year. So it's important to make sure that your employee handbook is up to date. There's been a lot of changes this past, 12, 18, 24 months. There's going to be a lot more changes in the next 12 months. But an important thing to keep in mind is consider updating your handbook as we head into the new year. There's a couple reasons for that. Number one, it's the most important document, in my opinion, that you have as an employer. It's the first document, one of the first documents after the offer letter that your new employees are going to see, and they're going to give them an insight in terms of the lay of the land, in terms of what's required, what's prohibited, what employees can do and can't do. On top of all that, if there is ever a dispute, be it an ADA claim, be it discrimination or harassment claim, the first thing I do when I respond to these claims by the federal or state agencies is I attach a copy of the relevant portions of the employee handbook regarding that issue. And I show the relevant agency that, hey, we take this seriously. Here's our policy in our handbook. We don't tolerate, harassment, discrimination, what have you, whatever the claim is based upon. And that goes a long way to showing that the employer is in compliance or has tried to comply as much as they can with the law. And it does buy you a lot of good grace with the federal agencies that, hey, this isn't some fly-by-night industry just making things up as they go along. They took the time to make a handbook and they have policies and procedures that are in place for their employees to cover these issues. It is important to update your handbook at least annually. Different state laws go into effect at different times. I was looking at Minnesota had a whole bunch go into effect August 1st of this year, and then a whole bunch more are going to go into effect January 1st of next year. And then they've got some crazy things starting in March, April, August, November next year. So they kind of spread things out. Other states do it annually. Other states do things biannually. It's kind of a mixed bag, but you need to make sure that at least annually you're taking a look at your handbook, make sure that you're up to date. Because federal, state, and local laws frequently change, laws have passed. New employment laws are passed all the time around the country. On top of that, existing employment laws may change either because the statutory language has changed or regulations are passed, or there might be a court case that comes in or an agency decision that comes in and changes what is legal or not legal. And I'm specifically referencing changes made with the National Labor Relations Board. Their general counsel has been fairly active in terms of changing the interpretations of the National Labor Relations Act that applies to all employers, whether you're a union shop or not. So it's important to make sure that your handbook is up to date. Anything that was not updated after August of 23 is going to be out of date just in terms of National Labor Relations Act compliance. When you're doing your employee handbook, don't use something you found off the internet. Sometimes those are okay. Sometimes they are quite honestly junk. It's risky. Any document that's produced that way could miss key information that applies to you. Maybe you're a small employer and that handbook or whatever you get has information about for employers that are 50 plus, like FMLA. Well, if you put that in your handbook, you have then subjected yourself to it when you could have avoided having to comply with FMLA if you had not promised it in your handbook. So even though you might find something that's, you know, quote unquote free on the internet, it could end up costing you a lot more money down the road. For those of you who are myHRcounsel clients, check in with us. A lot of our service levels include our best practices employee handbook. It gets you the policies that you need to pass along to your employees, and it can be updated every year. And with that, we're going to go to the next slide with Michael.
Yeah, as we're approaching the end of the year, you're an employer, you're one of the decision makers at your company, you're looking ahead to some of the things that you need to do as the end of the year gets closer. Make sure that you're providing notices to your employees that are required by law. As we just talked about, an employee handbook is a good way to cover some of that. You can really get a lot of important information to your employees. It not only protects your company, as Andrew just mentioned, but it also covers your bases on providing required information to employees in a lot of cases. Some states are very specific. They have very specific requirements on the types of information that has to be passed along to employees. There are also sometimes federal requirements, or there are federal requirements on information that needs to be provided. So that's something that you want to think about as we're coming up on January, not too far down the road here. An example of a state situation would be Massachusetts. A sexual harassment policy must be provided to employees at hire, and it also must be provided to your employees annually. So that's even outside of a handbook. That could be a standalone policy that some employers choose to provide, or they could do it in an employee handbook as well, as long as they're updating that handbook annually. But that's an example of a state law where you have to provide a required notice to an employee. The other thing that we just talked about are workplace posters. So you could think of things like federal, state, and even sometimes local places of employment need to have certain items provided to their workforce. There are a lot of bigger cities, if you have employees in any of those, that have specific requirements for postings that must be in a workplace. So if you have a physical workplace, a lot of times the posters, whether they're federal, state, or local, have to go up in a break room, in a place where employees change, something like that, someplace where everybody can see them. The posters also have to be provided to your remote workers, and that could involve, sometimes they're sent by email, sometimes they're provided through an employer portal. In either case, if they're sent electronically, you want to have a mechanism for tracking that the employees have received those items. And we also, through one of our partners, we have a solution as well that can provide necessary workplace postings if needed. So you can reach out to us on that if you have a question. Another area that you want to look at as the new year approaches is you want to look ahead. What are your staffing needs going to be for the upcoming year? If you're going to be hiring workers, that's a good sign, but you need to plan ahead. You want to look at your team structures, what employees will be added, where are they going to fit in? You want to start planning that in advance. You also want to make sure that your position descriptions are well done, and that's something that we talk about quite a bit with our clients. Make sure the essential functions of the job are included in any job position. You want those essential functions because that's going to be needed if you've got somebody that maybe has to have some time off, they become disabled. Under federal and state law, you're going to want to have really detailed job descriptions with the essential functions so that you don't get hung up on some sort of disability discrimination claim when you're looking at how to accommodate somebody. Another thing that you want to consider if you're going to be staffing up is your budgeting needs. Plan for those costs of new hires in advance as much as you can. The other side of that coin is if you think that maybe you're going to have an adjustment in the size of your workforce downward, you'll want to start planning ahead if you're going to do a reduction in force at some point in the upcoming year. There are some laws that can apply. One is the WARN Act, and there's also state law equivalents called mini WARN Acts that are basically notice laws. If you're an employer of a certain size and you're going to be making a certain amount of reduction in a workforce, if that federal law covers you or a state law covers you, then you need to provide advance notice to the employees. You need to provide, in some cases, notice to certain governmental authorities. That's just another thing to consider. A big topic that we do discuss frequently is if you're letting somebody go, generally, whether an individual termination or through a reduction in forces, well, do I have to pay this person severance? Well, and the answer to that is, of course, it depends. If you've got an at-will workforce, it's generally not required, but a payment of severance in exchange for a separation and release of claims agreement can be a good way to help limit your risk. If you've got workers that have maybe an employment contract or you've got some unionized employees, you want to look at those documents because there could be some requirements for severance under those types of circumstances. But again, this is just to make sure that you're looking ahead, you're planning as the year's coming up, whether you're adding people or whether people are going to be going out of your workforce. These are some of the things that you want to keep in mind. And Andrew's got some additional insights now on some wages and benefits questions.
Thanks, Michael. Talking about, I got an echo.
You're good on our side. We don't hear it.
All right, good. So what we're talking about here is minimum wage changes. And I looked at the list when I was updating the handbook templates, and it looks like just shy of half the states, or well, maybe not all states, but just short of 25 jurisdictions are going to change the minimum wage rate in 2025. So the federal rate is still stuck at 7.25, but the states and local municipalities have taken that into their own hands, and this is a theme we're going to see throughout the rest of this presentation. Is that when the feds don't act, the state and local governments do. So make sure that you're aware what the minimum wage is in your jurisdiction. Is it changing? And I don't think Minnesota, off the top of my head, changed the rules regarding whether or not there's a small employer anymore. I think it's one wage rate for all employers. And they also reduced or actually eliminated the tier for training or minor employees. So it's one minimum wage across the board in Minnesota, which makes things easier. But if you were a smaller employer and you were underneath that employee threshold and not considered a large employer, it's going to be another step that you're going to have to pay attention to. So make sure you're paying attention to that and making sure that, for the ones that go into effect Jan 1, that you're on board and ready to make those wage increases as they happen. We were going to talk a whole bunch today about the federal exempt salary threshold change, but giving the ruling last week Friday is a moot point. We do still have a slide on it just to discuss it, but spoiler alert, the Fifth Circuit said no dice, the DOL can't do what they did. And so the exemptions threshold salary exemption rate has been killed in its entirety and goes back to the previous rule. That said, some states have their own exempt salary levels and duties test. I'm looking at you, California. I know Wisconsin has some different duties that are required in order to be considered exempt under state law. So even if you meet the federal requirements, if you don't meet the Wisconsin requirements, you're not going to be considered exempt under Wisconsin law, and then you will have to pay attention to the Wisconsin overtime rules as well. So make sure that the states that you're working in, either you're paying attention to their salary levels, which are increased, like in California, or their duties test, which are different in some states. If you don't meet the salary level, or the duties test, again, the exempt employee is going to be not considered to be exempt, and they're going to have to be paid overtime. Minimum wage, not usually an issue, but also something to pay attention to in case it pops up. Payroll compliance. Make sure that your employee information is up to date. That can be payroll status, making sure that people are properly classified in your HCM or HRIS or your payroll software, to make sure that if they are getting an increase in pay because they're hourly, that they're actually correctly labeled in the system as hourly, so that when the increase happens at the state level, that they're getting paid the correct amount. Addresses, this is a good time to check for addresses. If you have to mail out W-2s, it's important to know where you're going to mail those to avoid headaches, at the end of January when your employee calls up and says, hey, I never got my W-2, I can't do my taxes. And finally, with payroll compliance, make sure you have Social Security numbers. It's really probably hard to do payroll without a Social Security number. I have run across, a handful of times in my 10 years at myHRcounsel where people have said, people quit before they finish the I-9 or their W-2, so we don't know what to do. There are special procedures for handling those situations where you do not have a Social Security number, but make sure that if you're missing something, that's something that gets cleaned up. On the benefits side, dependent audits. These, you can usually use a third party for these. What they do is they basically go through your health and welfare plans, and they determine if everyone who is considered on the plan or dependent on the plan is actually eligible. That includes making sure that nobody's aged out, so that nobody over the age of 26 would be still on your plan. Have people gotten divorced? Is there someone who is no longer around? They deceased and they need to be removed from the plan. And those can have some significant savings in terms of your bottom line, just in terms of reduced premium amounts. And my understanding, based upon the studies I've seen and anecdotally talking to companies that have performed these dependent care audits, is that at the very least they pay for themselves, but generally they end up saving the company a lot more money than they spend on them. Affordable Care Act. Is this the last year we have to worry about Affordable Care Act reporting? Who knows? But considering the Trump administration does not begin officially until January 20th, and I don't think they're going to have time to change it before the filings are due, you're going to still have to be ready to do your ACA reporting. Once again, that's something required for employers with 50 or more full-time equivalent employees. Make sure your reporting is up to date, make sure your software is configured correctly so that you can do that reporting, and make sure that you know what codes to use when you're doing those 1094s and 1095s. FSAs, flexible spending accounts, medical have increased their rates to $3,300 for the year 2025. So if you have to change your enrollment information or your annual notices, or I don't think you'll have to change your plan at all. Most plan documents aren't that rigid where they indicate what the amount is. They usually tie it to whatever the federal limit is, and they just refer to it that way. But perhaps your documents are rigid, that they state the exact amount that you can contribute as a cap. If so, make sure that you change those. Fringe benefits, 401ks, other benefit plans, wellness programs, dental and vision insurance. Make sure that you're up to date on those. Check with your benefits broker to make sure that nothing needs your attention in terms of updates or changes. And we're probably a little past open enrollment for those on a calendar year plan, but just keep an eye on costs and obligations of providing these plans to your employees. You can talk with benefits brokers to see if there's something that you're missing, or something that would be a really good value add for your employees that would not take a lot of effort or money on your part.
Andy, it's Mark Young here. Let me just add one last thing on benefits. There's a lot of confusion, whether it's the ACA or ERISA, on what different things you have to, documents that you have to send out on an annual basis based on the numbers. So, you know, as you touched on the Affordable Care Act, it's 50 full-time equivalent employees or more require that the company follows the ACA. The other one that we see mixed up a fair amount is IRS Form 5500. That's if you have 100 participants or more. And then the third one that we seem to miss, and this is the thing that we're going to touch on December 12th on ERISA, is there are documents that have to go out even if you have just one employee that is on a benefit plan, welfare benefit plan that you put together. So there's the one, there's the 50, there's the 100, and then there's some state requirements in that. So definitely worth your time to sit in for a half an hour, or if you're not sure, literally, you know, just put the question in a ticket and let us give you the answer.
Thanks, Mark. We're going to look at next, as you're approaching the end of the year, some things to consider with your time off with your employees. You want to check as you approach the end of December coming up into 2025 here, you want to check your employee time off balances, starting if you offer it with your vacation or your PTO plan. A lot of employers like to have a use it or lose it policy. They feel it's cleaner. The employee gets time. If they don't use it up, you know, too bad. That is legal in a good number of states, but it's also definitely not legal in some other states. For example, California, all awarded vacation is considered wages. And then to kind of flip the coin on in terms of the state philosophies, even in North Dakota, once you have an employee who's been awarded or earned their vacation time, it cannot be taken away. So those are just kind of two examples of states where if you offer vacation or PTO, you've got to be aware of what the balances are heading into the end of the year, and then what you can do or not do with those balances. Another area that we receive quite a few questions on are what happens with employee time off balances if you're in a jurisdiction or you're a multi-state employer. You've got state or city mandated paid sick leave or paid family leave. If you're in some of these states that mandate these benefits by law be provided to employees, what do you do with these benefits? So with those types of questions, you'll want to be familiar with what the rules are where you're operating. You'll want to check if there's any caps on balances, and you'll also want to know, hey, what happens if my employee leaves at some point? Do I have to pay them out, or what if they leave and come back? Are there reinstatement rules? As Andy mentioned earlier, the states and localities are getting into areas where they feel the federal government hasn't stepped up in a way that they'd like to see in terms of providing things like paid family leave or paid time off to employees. So with these states and these cities and counties providing these benefits, if you're a multi-location employer, you really want to make sure you know what those rules are regarding that paid sick leave or paid family time. And that's also something we get questions on that basically daily. We can assist you on that if you're one of our clients as well. Andrew's going to talk now about some performance review issues.
Yeah, end of the year is generally a typical time where employers will do annual performance reviews so that they can update, provide any increases in salary or comp starting Jan 1. And it's also a good time to evaluate what your performance review process actually is. So do you perform annual formal performance reviews? Ideally, You do them on an ongoing basis. It's going to help keep down the surprise factor if an employee isn't doing well. And it also offers an opportunity for employers to correct issues sooner rather than later. And what I mean by that is, have your manager do check-ins, and maybe you're doing one-on-ones, and don't wait until the annual performance review process to discuss what is not going well or what could be improved with the employee's performance. And in fact, you shouldn't even wait until a meeting that is already set up. If a manager is aware of something, it's best to do it on the spot right away to correct that performance, just so that you can nip things in the bud and things don't fester and become worse. Next part on that is, if you do performance reviews, when do you do them? Some do a formal sit-down process annually, some do quarterly, some do 360 reviews, some do goal setting. There's a whole bunch of different ways in which you can handle this. The law does not require you to do it. The law does not state you have to give anyone a raise ever, theoretically, except for complying with minimum wage or salary exempt threshold levels. But it's a best practice just to make sure that everyone's on the same page. No matter when you do it you do it on anniversary date? Do you do it year end? Do you do it at the end of your fiscal year, if your fiscal year is something other than a calendar year? So just make sure that you're doing it, just so that you can address issues, even if it's not super formal. If it's informally done by the manager to address issues as they arise, that's way better than not doing anything. If you do, however, have a formal review process, if you have a schedule, stick to your schedule. Employees who do not get that annual review when they're scheduled are going to be, annoyed. They're going to be let down. They expected X, Y, and Z. And if you don't keep to it, you don't keep your schedule, it's going to, decrease morale, and it's going to cause suspicion amongst employees. Maybe they're like, well, I didn't get a raise. Maybe the company's not doing so well. Maybe I should start looking, and that's going to increase your turnover. Going off schedule creates, the risk that I mentioned. Consistency here is key. Let employees know what to expect, and then follow through on what you tell them to expect. Make sure that everyone is being treated fairly. Make sure that no employees are being treated differently from others that are ways that could be seen as discriminatory. It could be the basis for a claim against you for violating discrimination rules or discrimination laws, either on the federal or state level. So those are also something to keep an eye on, to make sure that your managers are following through with the schedule that has been laid down from on top. We mentioned this earlier. I mentioned this earlier, but the exempt employee changes. I wish I had a big X put right through this screen, but I'm not that good with PowerPoint. The issue here is that earlier this year, the Department of Labor indicated that there's going to be an increase in the salary exempt threshold level in 2 steps. One that would affect employees as of July 1, 2024, and the second step that would take place on January 1, 2025. On Friday last week, the Fifth Circuit Court that had been hearing the case made a decision. Earlier this year, actually, they had exempted the state of Texas as an employer from having to comply with the DOL's July 1st rule while they were examining the rest of the issue. It took them until November to decide that the entire rule, even the one that went into place in July, was an overreach in terms of what the DOL's power had to do. And a lot of this is we're gonna talk about this on slide 10 in terms of why. We're gonna talk about Chevron and a whole bunch of stuff. But the issue being that the rule that everyone had been preparing for, and in fact, some places has already, some businesses had already put into effect, especially the July 1 rule, and some had anticipatorily put into place salary increases for January 1, is dead. So now you have to switch gears. If you've already raised salaries, what do you want to do? Do you want to decrease salaries for either the July 1st or the Jan 1 increase? Do you want to decrease them? It's up to you. If you do decide to attempt to reduce salary, make sure that you're also still in compliance with state and local laws regarding exempt thresholds. Again, California has different thresholds than the federal level, so make sure that you're not running afoul of any of those rules. And also take into account morale implications that accompany decrease in pay. If you are an employee that had a certain amount of money coming to you, and then your company says, well, we're gonna decrease your salary by $8,000 because we don't have to pay you much anymore, how likely are you to stay in that position? I think if somebody were to receive a sudden $8,000 salary decrease, that would be something that would cause them to start looking for a position elsewhere. And if you do roll back prior increases, and it's legal under your state law, also think about doing it to everybody rather than doing it onesie-twosie. If you do it onesie-twosie, you raise the risk of somebody claiming discriminatory animus, that is saying that you did it based upon a discriminatory basis because of their being part of a particular protected class. So that's an issue that you really need to look out for. But if you just do it to everybody across the board, that argument dies before it even gets born. And with that, we're going to get into the next slide, which is a whole bunch of stuff about what's going to happen, and we're going to dig a little bit more into Chevron.
Yeah, thanks, Andrew. I'm just going to talk, folks, briefly about this Chevron decision without getting too far in the weeds legally, but it's an important thing for employers to know about how we got here, what's going on, and why are we even talking about this. So there was a former case that was very precedential, and it was this Chevron decision, and it birthed the Chevron doctrine, and it required courts to defer to a government agency's interpretation of a federal statute if the statute was ambiguous. So in other words, if there's a statute out there, the agency that basically administers the rules of that statute, they're going to make the call on what the statute really means. What happened this year was that the Chevron doctrine was overturned by another Supreme Court case, and that newer Supreme Court case called Loper-Bright requires that courts exercise independent judgment when interpreting statutes. The courts do not defer to an agency interpretation of the law simply because a statute is ambiguous. So what this did is it took away an agency's power to interpret a statute if it was considered ambiguous, and then gave that power to a district court if somebody brought up an issue in court regarding a federal rule or a law. Now the judge or the court has the ability to interpret the law, not the administrative agency. So this has opened up more challenges to and more interpretation of federal regulations, and what we're going to see, and we'll talk about this a little more, we're going to see kind of a patchwork potentially of rules across the country where there is an administrative agency decision. The administrative agency doesn't get to make a call on it anymore if it's considered ambiguous. Instead, it's going to go to a court. A court's going to make a decision. Understand that federal courts are geographic and they have sway over certain areas. So you could see with some federal rules different results or a patchwork across the country. So that's one possible decision, as now we get into talking more about the philosophy of the incoming federal administration. This is sort of an overlay of where things are at even before we get to the new administration. But I think Andy wants to talk about some federal agency issues.
Yeah, and I mean, just following up on that Chevron case, is what you have essentially is a federal judge substituting their interpretation for the federal agency's interpretation. And so this becomes kind of a whack-a-mole situation where you don't know what you're going to get. With an agency making a decision, you know what the administration's point of view is going to be. Here, and the administration and the agency theoretically has some experience with the area. Here you have a federal judge who could have been, an assistant U.S. attorney making a decision about, Social Security benefits that he disagrees with Health and Human Services on. And so I think there's going to be some, I don't know, questionable decisions that might pop up due to lack of experience at the judicial level. But to go even further, all that we have to do to avoid this is have Congress write rules that are not ambiguous and write statutes that are not ambiguous. But if you believe that's going to happen, I've got a bridge for sale in Florida over some swampland, to mix my metaphors. That said, the new administration is going to have a change at the head of all these federal agencies. And that's going to be a complete change of philosophy. The idea here is deregulation and, laissez-faire and let the market figure things out. But at the same time, I don't believe that it's going to be completely deregulation. I think we're going to see some, potential new regulations come into place that we're going to talk about just a little bit with the employee leave section. In fact, I'm just going to jump ahead. Both parties running for president had indicated they had been open to the idea of paid federal leave or paid family leave at the federal level. And I've read some interviews with J.D. Vance, who claims that it's going to be a priority for him in this administration to get paid federal family leave. And so that's something to keep in mind on. But we have other issues among the agencies. We've got the NLRB, which I said has been running kind of amok the past 2 years or so, and changing all their interpretations of what the ruling is. Been very not only union friendly in terms of snap elections and stuff like that, but also friendly to employees in general. With the head, the new general counsel most likely being hired on January 21st, you're going to see that change pretty quickly. And then President Trump is going to have the ability to appoint members to the NLRB that are going to be more sympathetic to his point of view, and we'll probably see some decisions, overturn decisions that have been made in the past 4 years. And so the pendulum, as they say, is going to swing back to where it was before. The Department of Labor likely aren't going to be pursuing headhunting for companies to try to find or pinch. Instead, they're going to probably look to provide more guidance to employers through opinion letters, as has been done in the past. And other things are probably dead, like the FCC's rule on non-competes. I think you're going to see the federal assault on non-compete agreements go away in the next 4 years. And as Michael talked about, there's going to be some sort of patchwork interpretations of these federal laws. And Michael, do you want to talk about how you think states are going to react to all this?
Yeah, and we've kind of led up to this, but again, with kind of the pendulum swinging back the other way soon at the federal level, what we see either way, if either party is in charge and they make certain decisions relating to employment law or agency decisions along those lines, then the states who maybe don't agree with it, they are going to come up with their own rules to kind of cover that. So where we're going into now, we're going to see probably the more employee-friendly states pass even more rules that are more employee-friendly and thus likely more burdensome for employers. So think of places like California, Colorado, New York, New Jersey, Massachusetts, Washington, Oregon, Illinois. They already have a pretty strong game of passing laws, more and more laws that are employee friendly. Well, I think that game's going to get upped after the new federal administration comes in, because they're going to want to try to counter or stay ahead of anything that they're going to try to do. I would expect an acceleration of employee friendly laws to be passed in these states. That's going to lead to more compliance challenges, whether rules are swinging back and forth, kind of like we've just been talking about at the federal level, or if you've got states that are getting more aggressive with the rules that they're passing to protect their employees. We really are going to see quite a lot of change coming up in the near future. But the good news is that we're here to assist when you have questions. If you operate in one location only, there could be changes, certainly federal changes that could affect you, even state changes. But if you're a multi-jurisdictional employer, you've got employees in one or more states or different cities within a state, there's different rules sometimes. That's what we're here to help you with. We can advise as these changes come along, because there will be changes that are coming. Some of the other things that we're going to look at is, Andy touched on the minimum wage. He talked about paid employee leave. The non-compete issue, it's not likely that that's going to get hammered on very hard. Independent contractor rule, that might change slightly to be more employer friendly, but I think, and also immigration law, there's going to be changes there. Expect more enforcement activities, and that means if you're sponsoring somebody on, say, an H-1B visa, you're going to really have to stay on top of that. In terms of when you're hiring, or if somebody's let go, there's going to be much more overall immigration enforcement. And I think Mark wanted to mention some information on joint employment as well.
Yeah, I just, joint employment, the law and the regulations from the NLRB prior to Chevron was flipping a coin about every 2 months. And it was a gigantic deal for staffing firms and for franchisors, because if you're a franchisor, you used to be able to provide your franchisees with employee handbooks and the 7 documents or so we always say that is needed in each franchisee, because they are separate employers. The franchisor is not the employer. So even in an offer letter to a franchisee employee, you got to make sure that that offer letter says you work for the franchisee. And again, over the last 2 years, in all of our franchisee associations, the speaking engagements that we've done, that has changed every couple of months. It's just, I don't remember a time, doing this for 32 years, there's a few times where this happens where all 3 branches are of the same political party. And I think once before did we swing kind of away from the federal agencies making up the rules, which means that more and more states get involved. And it makes it even more confusing, I believe, especially the next 2 years. So if you're sitting there going, okay, well, great, Mark, and guys, what do we do? You have a subscription that is, gives you unlimited legal advice. We have the webinars. We have a weekly updated Tuesday at 10 o'clock set of reviews, if you would, in our newsletter. Follow, our LinkedIn and Insta, and make sure that you're seeing the updates. And when we first started, Google is not a law firm. Don't Google for law firms, and then just be very careful. Consulting firms and associations and that are also not law firms, and they can't provide legal advice. They can give you just in general some overview, but they do have to disclaim what information they give. It's not attorney-client privilege, and it's not legal advice. So just remember, again, not pushing take us, but you already have us. And so if you're not sure, no reason not to open a ticket. Doesn't cost you anything more. And again, if you're not tracking with the newsletter, or you're following us on the different social media platforms, just make sure you update that, because we are going to get, obviously going to be in front of it probably in the week that they make those changes. Guys, anything to add on that?
I think that captures it, folks. If you're already one of our clients, you have access to these webinars, as Mark noted. Also, we do the weekly newsletter every Tuesday. It's full of really good information, included sort of breaking news and items that you need to be aware of as an employer. And also, mainly, if you're an Ask HR client, you've got access to the attorneys. You get unlimited legal advice on these matters. And reach out to us if you've got a question on some of this stuff, because there are going to be a lot of changes happening. Make sure that you do utilize, if you've got a question, if you have our service, definitely reach out and let us know, because we're monitoring and we are learning as we go along to keep an eye on this stuff, and then we can pass along what we're proactively looking at to you. And Andy, I think, has something he wants to add as well.
Yeah, again, I'm going to hammer employee handbooks. I'm going to hammer keeping an eye on our newsletter. I mean, one thing I didn't mention was, immigration was a big platform of this presidential campaign, and it would make too much sense to me for, now that the Republicans have 3 branches of government, to require everyone to use E-Verify instead of I-9s when they hire, if they truly want to be sure that everyone in the country is valid to work. That's just too easy of a way to do it. And so I would, if you're not an E-Verify user, just keep an eye on that, just in case that comes down the road.
And our info's there, everybody. If you're not a client, reach out. If you want to use our services, and if you are a client and you have questions, use the portal, as we said. Thanks, everybody. And I think Dan's got some closing remarks as well.
I believe he's on mute. There we go.
Sorry about that. Yeah, thanks, Michael, and thanks, Mark and Andy as well. That was great information. As we said already, subscribe to our newsletter. It's free. It's got great information to help you keep on top of these law changes. And all of the HR and employment issues are included in our Ask HR service. It's affordable. It's a flat fee each month. We'd be happy to share more information about that. And as I mentioned in the beginning of the webinar, we will be sending out a follow-up email, which will include more information, that recording, slide deck, and then invitations for future webinars. Thanks again. We hope you have a great rest of the day.
Thanks, everyone.
Yep, thanks.